Welcome to the Mary Ewing Law Show.
Hello and welcome to the Mary Ewing Law Show. Mary is a veteran Colorado attorney who has spent more than 40 years helping clients navigate workers' compensation, personal injury, and family law cases. Known for her no-nonsense approach and genuine compassion, she helps injured workers understand their rights and protect themselves from unfair treatment. I'm Kevin Rosenquist, and today Mary will explain whether or not you can get fired for filing a workers' comp claim in Colorado. Mary, welcome. It's good to see you.
Hey, thank you. I'm happy to be here.
Well, I was going to say, this is something a lot of people worry about. When someone first tells you that they're afraid to file a claim because of their job, what's your reaction?
Well, in Colorado, that's really not necessary. Generally speaking, it's a legal right, almost without exception. It's a legal right to file a workers' compensation claim if the employer retaliates in any way, any manner, then it creates a whole new claim against the employer. Honestly, I don't really see that, except when the employer is not insured for workers' comp.
Oh, okay. Yeah, that's not
And,
great.
and that can be an issue.
Yeah.
Maybe I can follow up with that if the employer is uninsured, and he knows that he's supposed to be insured, and he knows or should know that he's responsible for paying the medical expenses and at least part of the wage loss of the person. But if he's uninsured, he also has penalties against him. So he's in a tough bind, and rightly so. He got himself in that.
Sure.
And the employee, the injured worker, can actually decide to sue the employer if there's any negligence, or he could pursue the claim for workers' comp. But as I said, there are penalties under the Workers' Comp Act if an employer is uninsured. So it's a big deal for employers not to carry insurance.
So they can't fire someone just for filing. Are there subtle ways that you've seen employers kind of retaliate against people?
Honestly, really only if the employer is uninsured.
Really? So it really is just that, huh?
Yeah. Mm-hmm.
What signs should an injured worker look for that might mean their employer is crossing the line?
If the employer is retaliating by cutting hours or changing schedules or changing the position, then the person is, number one, aware of that. And what they should do is document the date, the time, the person who is treating them unfairly, and they need to seek help through the Colorado Civil Rights Division or the federal EEOC, and or hire a lawyer.
Documentation, you said. Emails, schedule changes, conversations. Like, what are we talking about as far as documentation goes?
Everything that they possibly can write down. Start a diary showing what's happening. Write down who's there. When did it happen? What was said? What were the results? Did they complain to HR, human resources? Maybe it's a company that's not big enough to have a human resources, but if there is, for sure, contact the human resources. And if there is an email opportunity that they could contact the employer and object to what's happening, then for goodness sakes, do that.
How difficult is it to prove this sort of thing? Like let's say, let me give you an example. Let's say that, someone is getting their hours cut or getting, maybe perhaps they're even let go, and it's, supposedly performance reasons or something like that, but someone is pretty convinced that it's because of the injury, because of the claim. What kind of likelihood is it that someone has a good defense for that?
Well, probably they don't. But the questions I would ask this injured worker, what's happening is she still suffering from the on-the-job injury? Does he have or she have work restrictions? If he's on work restrictions, is the employer following those and giving him work within the restrictions? If he's terminated while on restrictions, he's entitled to go on full workers' compensation, temporary disability benefits. So there are remedies if that happens.
What about if I don't know, if an employer doesn't think that the injury happened at work or something like that? Is there something that they can do to try to, I don't know, find evidence of it?
It's called contesting the issue, contesting the claim, but they're going to have to come up with some legitimate proof, either from other employees or the failure to report early or something happened before or at home. It's going to have to be something other than just, I don't think he got hurt at work. Got to have more than that.
Got to have more than that. Yeah, that makes sense to me. That makes sense. What about insurance companies? Do they play any role in this?
Sure, they do. They're the people with the money. Simply stated, insurance companies like to see workers get back to work. If the worker is on restrictions, the employer has the opportunity to offer work within restrictions. Doesn't have to be the injured worker's regular job. It may be something that he or she hasn't done at all. But if it's in work restrictions, then the employee has to accept that, or he'll lose his right to benefits. If the employer doesn't provide work within restrictions, then the employee is entitled to go on, as I said, full workers' compensation benefits.
Okay. And for people who can't go back to work because of the injury, how does the law handle job loss in that situation?
Sure, that is a multi-layered question.
All right. I like that.
If the person who's permanently physically impaired, then the worker is entitled to disability benefits. The benefit is determined based on the degree of disability that the authorized treating physician has determined. It's an objective test, not a pain test. And amazingly, this is beyond belief, but it's true, the statute references that it's to be done by the AMA Guide to Permanent Impairment, third edition. Now, I'm not sure what edition we're on now, but it might be 12th.
Oh,
You
gosh.
literally can't, yeah, you literally cannot buy that text. You have to find somebody that has a copy that you could copy, or you may be able to get it from the carrier. But it's an objective test where their range of motion is determined, various objective signs. Now, if the injured worker is unable to be engaged in any employment, any gainful employment, then he is entitled to permanent disability benefits, which you can be sure that the insurance company is going to fight like the Dickens to not pay that. But if the injured worker truly can't work, and there are objective signs, he probably needs a lawyer, but he's certainly entitled to permanent disability.
So without giving away any trade secrets, what kind of approach do you take in that situation when you're defending that employee?
I like to see if I could get, let's say the authorized treating physician that the insurance company has sent the worker to, and the worker's rating is something less than complete. I like to send the employee to another doctor, has to be at his expense, to do his own rating and be prepared to present his testimony based on the reality of the situation. It's also helpful to get a vocational rehabilitation assessment. Those are the folks that have the expertise in determining whether somebody is capable of obtaining replacement employment. And they can be a godsend in proving that total disability case.
I think there might be a narrative out there for some people that the workers' comp system is abused too much. Is that a fair assessment in your mind, or is that just an over exaggeration?
The media likes to play that.
Yeah.
Every once in a while, you start seeing lots of things of this person or that person was cheating. I've been in practice a long time. And honestly, I have only questioned a client about whether they were really hurt. People are generally honest about what's happened to them.
Hmm.
And they have documentation. They've gone to the doctor, or they've told their friends, or they've told their coworker. There's something that is out there that can support what they're saying happened. And I find that not true.
Hmm.
But I like to
Yeah.
believe my clients too.
Yeah, absolutely. And you like to believe just humanity, right? That the people aren't taking advantage of
Right,
something designed to help people
right.
when they are truly hurt, for sure. So it sounds like from our conversation that as a general rule, employers just follow the letter of the law when it comes to workers' comp claims, and they don't necessarily react in a harsh way, at least not anything serious.
Oh, I'm not sure if I can generalize with that. Insurance companies are in business not to pay claims.
Sure.
And it might not be the employer's fault, but the insurance company might be fighting the claim. They do things like have surveillance films. They have often a cadre of doctors that are going to generally support their position.
Hmm.
So that happens without a doubt.
I mean, that's an all any claim, right? I mean, you do personal injury too, and I mean, obviously, insurance companies do everything they can not to pay. So it's no different in the workers' comp world, huh?
No, no, no different.
Okay.
The
If
law is a little bit more on the injured workers side,
okay.
I would say, in workers' comp cases.
So how's that balance when you have the law versus the insurance company's desire not to pay? Is that obviously you can, as a lawyer, you can use the law on your side to say, hey, no, this has to be paid. What kind of things do they try to do to get out of paying?
Uh, they look for another cause. They look for something, let's say the injured worker is a basketball player, plays pickup games,
Sure.
and he's claiming that he injured his arm. And the insurance company is going to say, well, 2 weeks before, you were in your primary doctor's office complaining about having sprained your wrist. And that's really, you're claiming a wrist injury now. We don't believe that you really had a work injury. You think it came from the basketball game that you'd been playing. Things like that.
Hmm. You mentioned surveillance. What are they looking for?
Anything that proves the person is not injured. Let me give you an
Yeah.
example. Um, let's say the worker is filmed taking a heavy garbage can out to the street, and there's a van on his street. He doesn't realize has an investigator who's filming him doing that.
It's like
Well,
a movie,
oh,
Mary.
absolutely. I call them spy films. I call them spy films.
Spy films.
But that might be the only time that person carried out the garbage. He might have had to go in and lay down or take
Right. Yeah.
pain meds,
Yeah.
uh, all sorts of things. But he's caught on film as though he's lying,
Hmm.
that kind of thing.
Yeah. I mean, you're absolutely right. He could have gone in and fallen on the couch, exasperated, and put ice on it, and whatever. You don't know.
Right, right. I mean, people
Yeah.
do have to live their lives even if they're injured,
Yeah. Garbage doesn't take itself out. I've tried.
unfortunately.
I've tried. All right. Thanks, Mary. Well, that's it for today's episode of the Mary Ewing Law Show. If you've been hurt on the job and you're worried about how your employer might react, Mary Ewing can help you understand your rights and protect your job while you recover. Visit maryewinglaw.com or call 303-886-5400. Thanks for listening. Don't forget to subscribe to our channel. Leave us a review if you found this episode helpful. Mary, great chatting with you. Thanks so much.
You're so welcome.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.